We have now discussed communication of acceptance and exceptions to the rules. Let's now look at mode of acceptance and its importance. There can be three types of mode of acceptance. 1. A method or mode of acceptance prescribed by the offeror. 2. Acceptance by conduct. 3. Acceptance by silence. If the offeror has prescribed the mode of acceptance in the contract, the offeree is generally expected to use that mode. Can you think of a situation where it would be okay for the offeree to use a mode of acceptance other than the prescribed one? What if the mode chosen by the offeree is a faster and a more reliable mode? Take a moment here, pause, and leave us your comment on our website. How will the situation differ if the offerer prescribes a mode and then goes on to say that only this mode of acceptance is good? Again, take a moment here, leave us your comments on our website. Now let's discuss the scenario where mode of acceptance is offeree's conduct. These situations are difficult to interpret than written words or speech. Consequently, this is an area in which the courts have been and tend to be very creative and look at the conduct as a whole in order to decide whether there has been a contract. In Brockden versus Metropolitan Railway 1877, Mr. Brockden had supplied the Metropolitan Railway Company with coals for a number of years. Brockden then suggested that a formal contract should be entered into between them for longer-term coal supply. Each side's agents met together and negotiated. Metropolitan's agents drew up some terms of agreement and sent them to Brockden. Brockden wrote in some parts which had been left blank. He wrote approved at the end and sent back the agreement documents. Metropolitan's agent filed the document and did nothing more. For a while, both acted according to the document's terms. But then some more serious disagreements arose, and Brockden argued that there had been no formal contract actually established. The House of Lords held that a contract had arisen by conduct, and Brockden had been in clear breach, so he must be liable. The word approved on the document with Brockden's name was binding on all partners, since Brockden was the chief partner, even though the standard signature of B and Sons was not used. A mere mental assent to the agreement's terms would not have been enough, but having acted on the terms made it so. General rule established in Felthouse versus Bindley 1862 is that silence cannot constitute an acceptance. In that case, a nephew and his uncle had negotiated the sale of nephew's horse. They misunderstood each other and became confused about the agreed price. In a letter, the uncle suggested that they split the difference and that if he heard no more about it, he would consider the sale done for this middle price. The nephew said nothing more to the uncle but clearly accepted the new price because he told his auctioneer to withdraw the horse from the auction in which it was to be sold, as he had already sold it to his uncle. The auctioneer nevertheless sold the horse in the auction by mistake, and then uncle sued him for interfering with his property rights over the horse, known as the tort of conversion. It was held that uncle had not become the owner of the horse, and therefore had no title to sue, because the contract of sale between the uncle and nephew lacked an acceptance, and so never existed. Exceptions in Vitol versus Norelf 1996, Lord Steyne noted that silence could constitute acceptance in exceptional circumstances. He cited the Court of Appeal in Rust versus Abbey Life 1979, where a woman's inaction over 7 months was thought to be sufficient to establish her acceptance of an investment policy taken out on her behalf. Consider a further related situation where the offeree takes the benefit of offered services when he had reasonable opportunity to reject them and reason to know that they were offered with the expectation of compensation. An example of this situation might be where a person washes car in his neighborhood thinking that someone might pay him. So he washes my car and I do not stop. Perhaps the obligation for me to pay should arise from unjust enrichment. I have been enriched or benefited at the car cleaner's expense by his efforts, and the remaining question is whether it was unjust. Now that we have discussed all of the applicable rules related to acceptance of an offer, let's discuss other responses to offer. When and how does an offer end? Some scenarios are revocation. Another one, conditions not fulfilled, where the offer is made subject to a condition which is not fulfilled, the offer terminates. The third condition is death of offeror. And another one is lapse. Let's look at a case that gives us rules applicable to revocation of an offer. In Dickinson versus Dodds, 1876, Dodds made an offer to Dickinson that remained open until 12th of June. Dodds sold the property he had offered for sale before any acceptance by Dickinson, and Dickinson heard about this from a third party. Despite this knowledge, Dickinson tried to accept the offer. Dodds refused to transfer the property, and Dickinson sued to enforce the contract. It was held that there was no contract between Dodds and Dickinson's. The Court of Appeal thought that the communication by the third party to Dickinson was tantamount to Dodds telling him, "I withdraw the offer." The other issue thrown up by Dickinson versus Dodds is the fact that even though the offer is stated to be open until a particular time, it can be revoked before that time. There is no enforceable promise to keep it open because there is nothing, no consideration given in return for any such promise. Of course, if the offeree pays for or gives something in return for the promise to keep the offer open, the promise to keep it open is then binding. Where an offer is made to the whole world or to an indeterminate number of persons at large, commonly but not exclusively in unilateral contract situations, it may be impartial or impossible to communicate the rejection to them all. In this case, it is generally accepted in line with an American case of Shue versus US, 1875, that it is enough if the offeror takes reasonable steps to publicize the revocation, which will generally involve giving the same amount of publicity to the revocation as to the original offer. It is arguably implicit in such an offer that it may be withdrawn by similar method to its initial publication. Or as Justice Strong said in the Supreme Court, the offeree should have known that it could be revoked in the manner in which it was made. Looking at this, it is safe to say that revocation does not need to come directly from the offerer. Some other points to keep in mind are: 1. Revocation cannot take place after acceptance since agreement has already been formed. 2. Revocation will not benefit from postal rule. In Dickinson versus Dodds, the offer was open until Friday 9:00 a.m. What would have happened had the offer not been revoked and had Dickinson not tried to accept it? Think about it. Would it have lapsed at 9 a.m.? Yes, you are right. It would have lapsed at 9 a.m. But remember, not all offers have specific expiry date and time. What would courts do in that situation? When would an offer lapse if there is no specific expiry time and date? Ramsgate Victoria Hotel versus Montefiore. An offer was made in early June to purchase shares in the hotel company. Montefiore heard nothing until late November, when he was informed that he had been allotted shares in the hotel company. He refused to accept them, and the court agreed that the hotel company's acceptance had come too late because the offer had already expired by lapse of time. On this note, I conclude this lecture on responses to offer and end of an offer. I look forward to discussing our next topic of contract law with you soon.